I was in Central Park when my friend told me that Roe v. Wade was repealed. She slowly got it through my head that it was repealed that morning. I remember being taken by surprise because I had not read the news that morning, and it felt so soon after the leak had come out. Sometime later, I went to law school and took a semester in constitutional law, and I further learned just how awful the decision to repeal Roe v. Wade really was, and the far-reaching consequences it really could have concerning the meager rights this Constitution affords us. But first, I want to thank our sponsor, Atlas VPN. Do you make controversial videos on the internet? Me personally, I would never. But if you do, I have the VPN for you. With more than 6 million users worldwide, Atlas VPN works to make the internet more secure and accessible to everyone. This is the best VPN deal in the market. Enjoy the most affordable online protection for just $1.83 per month, plus 3 months extra with a 30-day money-back guarantee. Grab this big deal now. Unlock your favorite content from all over the world. Can't access Friends or other legendary shows on your Netflix while being abroad? That's not a problem anymore. Atlas VPN has got you covered. Keep Google searches in private. Looking for something on Google that you don't want someone to know about? Me too sometimes. That's where Atlas VPN has got you. Please make sure to consider this great deal. Now on to the video. For those not in the loop, the decision to take away the right to an abortion was done via a case called Dobbs v. Jackson Women's Health Organization that was decided in 2022. The facts aren't really that important concerning the impact this case has had, but just for those sticklers, Mississippi wanted to create a law that would ban abortions after the 15-week mark in a pregnancy, and Jackson Women's Health Organization said that this was against the established precedent of Roe v. Wade and other pro-choice decisions. In response to this controversy, the Supreme Court decided to do away with any holding that would regulate states in their decision to ban or allow abortion with or without considerations. So, Dobbs v. Jackson on its face and in the public mind is a case about abortion. But really, it is a case about a much broader legal issue: substantive due process. So, what exactly is that? To answer that question, I'm going to have to take you on a journey through the legal swamp that is our Constitution. So I want to start by putting this idea into everyone's heads. The Bill of Rights does not protect your rights. Not inherently, anyway. Crazy thing to say. But what do I mean by that? The Bill of Rights only prevents the federal government from infringing on things like free speech, the right to bear arms, and the right to due process of law, and etc. For the states, though, it was free real estate on our rights, and they could make laws infringing on any of these things if they wanted to. That wasn't until the Civil War. The idea of allowing the individual states to take whatever position they wanted on people's rights was very unpalatable in the years after the Civil War, and the 14th Amendment was created with that idea in mind. To combat states using their power to deprive people of liberties, the framers of the 14th Amendment included the following provision.
No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
In particular, I want to focus on two phrases. No state shall deprive any person of life, liberty, or property without due process of law, and that it won't deny to any person within its jurisdiction the equal protection of the laws. This is essentially the 14th Amendment saying that the Bill of Rights applies to the states. Over time, the court would incorporate the Bill of Rights into the 14th Amendment so that they would apply to all situations concerning federal and state legal issues. So if states want to go against any of the liberties involved in the Bill of Rights, they need to go through a legal process where those actions are reviewed and where the court will use a strict scrutiny standard where it will ask whether those policies serve a compelling government interest and whether the policy in question has taken the least restrictive measure possible to meet that interest. That's substantive due process. But abortion isn't mentioned in the Bill of Rights. Neither is the right to marry, or the right to keep families together, etc. A lot of our rights in this country are not part of the Bill of Rights, and thus the idea of using strict scrutiny to prevent government infringement of those rights is instead based on the idea of what the court calls a fundamental right. A fundamental right is any right that is implied by the other amendments, and proponents of something being a fundamental right pull from the Due Process Clause of the Constitution. The Due Process Clause says no state shall deprive any person of life, liberty, or property without due process of law. And proponents of whatever right will say that by not saying XYZ is a fundamental right, you are depriving people of life, liberty, or property without due process. So now that you completely understand the entire concept of substantive due process, which I explained flawlessly because I'm just so smart, let's turn to abortion. Roe v. Wade asserts that people have a right to privacy and says that it can be implied by either the 14th or 9th Amendment. It says that abortions can happen so long as they follow a trimester scheme and uses a strict scrutiny standard. Planned Parenthood v. Casey changed the standards on abortion regulation in a couple of ways. It changed the regulation to a scheme based on the viability of the fetus outside of the womb, and then it made any regulation valid so long as it did not place an undue burden on the pregnant person. It also bases the right to an abortion in the 14th Amendment's Due Process Clause. Dobbs v. Jackson did not just overturn Roe v. Wade and the right to an abortion. The court in Dobbs could have argued that the right to privacy was either not implied by the Constitution or that even if it did exist, it did not apply to abortion. No, instead, it went further and decided to apply a standard for deciding what is a fundamental right. As mentioned, fundamental rights require strict scrutiny to be abridged. This requires a compelling government interest in a law that is narrowly tailored to meet that interest when deciding to go against a fundamental right. The standard they applied is the standard of a case called Washington v. Glucksberg, which held that the Due Process Clause specially protects those fundamental rights and liberties which are objectively deeply rooted in this nation's history and tradition, so rooted in the traditions and conscience of our people as to be ranked as fundamental, and implicit in the concept of order liberty, such that neither liberty nor justice would exist if they were sacrificed. Which means that if the right is not rooted in whatever the standard was at the time the amendment was created, then it's not going to be protected by the courts. You can see how Samuel Alito makes this argument by how he pulls on the history of states banning abortion via laws existing at a time when women could not vote. To Alito, this is not a threat to any of our fundamental rights at all. He says that
the dissent suggests that our decision calls into question Griswold, Eisenstadt, Lawrence, and Obergefell, but we have stated unequivocally that nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion.
By the way, Griswold and Eisenstadt give us the right to use contraceptives. Lawrence allows sodomy, being anal sex and oral sex, and Obergefell allows gay marriage. Clarence Thomas, on the other hand, agrees with me here that the applicable scope of substantive due process is threatened by the overturning of Roe v. Wade. He has said, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Though he only agrees with me in the sense that he is actively trying to make it happen. So cool. To me, it makes sense that if you limit fundamental rights to what was the tradition in the 1800s, it is only natural that we would lose things like abortion or gay rights. Abortion should naturally be seen as the first of these to go if the court continues down this trend. That's why I don't like this standard, and I personally think it's pretty lame. Now, I make videos about Israel and Palestine, so I'm no stranger to unhinged comments. That being said, I believe in you guys, and I'm sure I will not regret that. So, yeah.
To those critics that say that a preacher should not be living a life of luxury, what is your response to that?
They're wrong.
Oh my God, what was that? I genuinely have no idea how that made it in the video. But since we're on that topic now, $7 and up patrons get their names shouted out at the end of the video, and I would very much appreciate any contribution at all to helping this channel go by. I'd also appreciate if you guys subscribed, hit the like button, and commented, preferably something very sane and lucid. And without further ado, I'm going to thank the patrons. Big thank you to Avocado Kirby, Rod B, Justin Speaks, Pyrotic Napalm, Ravignon, Alex Ryanhard, and Doubly Triple. Thank you, and everyone have a good day. Also, before I forget, big thank you to Iseni and Legal Kimchi for providing voices in this video. You can find their channels in the description. They both cover legal topics as well, and they helped look over the script. So thank you very much. Go subscribe to those guys. They're great.